Good morning, this is your Kelso Report for Monday, July 16th, and I'm your host, Clark Kelso. We begin with a class action settlement case in the Ninth Circuit. Now, as you know, class action settlements must be approved by the court to ensure that class counsel and the named plaintiffs do not place their own interests above those of the absent class members. In Dennis v. Kellogg Company, a false advertising case, the Ninth Circuit reviewed a class action settlement negotiated prior to class certification that included a cypre distribution of money and food to unidentified charities. It also included $2 million in attorney's fees, which broke down to about $2,100 for an hourly rate, per hourly rate of $2,100, while offering class members a sum of at most $15. The Ninth Circuit set aside this settlement because the district court did not apply proper standards in reviewing the cypre award and because the attorney's fees were excessive. As for the cypre award, the Ninth Circuit was particularly concerned about how vague the award was, given that none of the recipients were identified, and there were no restrictions on recipients other than characterizing them as charities that feed the indigent. You can imagine all sorts of conflict of interests that would erupt in the context of that type of a cypre award, particularly when the attorneys were so greedy as to go for attorney's fees that amounted to $2,000 per hour. Good for the Ninth Circuit in rejecting such a one-sided settlement. Next, we have a couple of juvenile law cases from the California Court of Appeal. First, in its decision in In Re YM, the 4th District dealt with the complex interaction of state, federal, and international law in the context of human trafficking for sex, in this case by the U.S. resident father of a minor girl. The girl is a special needs child who was born and raised in Guatemala. When she was 14 years old, her father, who lived in California, arranged for her abduction and illegal entry into the United States. He then sexually and physically abused her and made her available to other men for sex. The abuse was discovered and she was declared a dependent of the juvenile court. A little later, federal authorities determined that she was a victim of human sexual trafficking and was entitled to protection under the Federal Trafficking Victims Protection Act of 2000 and the William Wilberforce Trafficking Victims Protection Reauthorization Act of 2008. The girl was initially placed in a special federal program for unaccompanied alien children. Several months later, over the girl's objection, the juvenile court terminated her dependency case, concluding that a Guatemalan protocol pertaining to victims of human sexual trafficking was equivalent to an international treaty, and it deprived it of jurisdiction. The 4th District reversed the termination of the dependency case. The Guatemalan Protocol was drafted by Guatemala in cooperation with the United Nations as part of the UN's global efforts to combat human trafficking, including trafficking for sexual purposes. Although the United States is a party to the broad UN protocol on this topic, the Guatemalan Protocol was nothing more than an internal document adopted by Guatemala, and therefore did not have the status of a treaty or federal law that might somehow divest the juvenile court of jurisdiction. Instead, the juvenile court is to retain jurisdiction and continue to apply state, federal, and international law concurrently, with due deference to federal and international law and practices, but always through the perspective of California's best interests of the child standard. Seems to be a very nice accommodation of 3 layers of law. Next, the minor dependent in Re OP had been charged with assault with a deadly weapon. A court found that he was not competent to stand trial. He was, as the 3rd District said in its opinion, slightly mentally retarded. And pursuant to a challenged special instruction that tracked the language of Section 6500 of the Welfare and Institutions Code, the jury found him dangerous solely because he was an incompetent defendant charged with a violent felony. The jury can make that finding given the instruction without making a specific finding that he was currently dangerous to himself or others. Now, a number of prior courts have noted that the statute as drafted denies due process because it permits a civil commitment without a finding of current dangerousness. The 3rd District in Re OP followed the lead of the other courts by generously construing the statute so that it does require a finding of current dangerousness, and so construed, the trial court in this case erroneously instructed the jury. The 3rd District reversed the commitment order and remanded. Now, it does seem to me this is one case where the courts should simply declare the statute unconstitutional and force the legislature to fix it. What we have now only invites error because litigants in courts look to the statute for guidance, and the guidance it gets there is unconstitutional. Next, we turn to a case involving public access to criminal trials. As a general matter, of course, criminal trials must be open to the public. However, the right to an open trial may give way to other values of constitutional importance, although such circumstances will be rare, and the balance of interest must be struck with care. In particular, both the defendant's and the public's rights may be subjected to reasonable restrictions that are necessary or convenient to the orderly procedure of trial, and the trial court retains broad discretion to control courtroom proceedings in a manner directed towards promoting the safety of witnesses and jurors. In People v. Penna, the 4th District affirmed the trial court's decision to exclude all of the defendant's family members from the last witness's testimony at a gang-related trial after 2 jurors complained that family members had made intimidating gestures toward the jury. Next, we deal with threats of force. The defendant in People v. Nishi was convicted following a jury trial of 1 count of attempting to deter or resist an executive officer in the performance of duty in violation of Penal Code Section 69. The evidence supporting the conviction was an email the defendant had sent to an Air Force office complaining that the California Department of Fish and Game had been repeatedly and unlawfully shooting at protected mountain lions in a certain area of Marin County. The email asked the federal government to take control of all wildlife activities in the Marin County Indian Valley Open Space Preserve. It then declared that the author of the email was, quote, armed and will now fire on all sheriff and fish and game after this email, so either shut them down or put some boots on the ground to join the battle. Remember that if they kill me, what is going to happen to the human race by Apollo or the same beings on Codex Dresden, close quote. The 1st District affirmed the conviction in the published portion of the opinion rejecting a First Amendment defense on grounds that a credible threat of violence is not protected speech. As the court explained, when a reasonable person would foresee that the context and import of his or her words will cause the listener to believe he or she will be subjected to physical violence, the threat falls outside First Amendment protections. And that's it for today's Kelso Report. Have a great day in the law.